One more.
Okay.
Okay,
Betty, did you still want me in?
yes, please. Okay, so Kristen, you
Shelley.
do not need to stay, and Shelley, you don't need to stay.
Okay.
Yep, Shelley, you're gonna have to hop off. Okay. Shelley, I'm gonna have to take you off. Okay, bye, Shelley. Okay,
Okay,
Madam Chair, for the record, roll call of the board members, Chair Meeker,
Here.
Don Barcelou,
Here.
Vince Granado,
Here.
Hilda Pareo.
Here.
And for the record, absent are Doug Ferguson, Mark Peters, and we don't have a seventh board position at this time. Madam Chair?
All right, in accordance to this executive session per ORS 192.660 subparagraph 2H, to consult with the legal counsel concerning the legal rights and duties of a public body with regard to current litigation or litigation likely to be filed. Once again, the press is welcome to attend, but cannot report on the findings or discussions during this meeting. With that, let me turn it over to y'all.
so before we get started, Kathy, are the only people that are present are the ones I see on the screen as board members and legal counsel?
Yes,
No one else on?
there is nobody else. There's a total of 9 participants, and if you're using your full screen, you should see us all.
Okay, so with me, we have our two new legal counsel, Matthew Shoup and Stacy Postgate. I asked them to join us in this session because we're going to be discussing current litigation with you regarding the Aurora Airport. So just as a reminder, a summary, there was a legal challenge filed by the cities of Aurora and Wilsonville, Thousand Friends, Friends of French Prairie, and an individual named Joseph Schaefer with the Land Use Board of Appeals. The trigger event was the October 31st State Aviation Board meeting, in which the board adopted findings of compatibility and compliance for the Aurora Airport Master Plan. It was immediately followed by a challenge by the 5 petitioners. It took about a year for this to get heard through LUBA, but the final hearing, the final decision and ruling by LUBA came out in December 16th of last year. And just to summarize what the petitioners were arguing, between the 5 petitioners, they had a combined total of 16 assignments of error. In 15 of those, they asked that LUBA reverse or remand the board's decisions. The petitioners argued that the board did not adopt the plan in 2011, and that even if they did, the board must adopt findings of compliance and compatibility at the same time that they adopt the plan, not 8 years later. That the board did not comply with the state agency coordination agreement, and that the findings of compatibility and compliance did not adequately address goal exceptions. Clackamas County and Wilsonville asserted that they are affected parties rather than interested parties, and that they have equal standing and equal rights as Marion County. The city of Aurora argued that an airport is an urban use and cannot be expanded in rural lands until the airport is annexed, that the master plan is not compatible with Marion County's comprehensive plan, and that ODA unlawfully delegated authority to the FAA. LUBA rejected every single argument that was made, all 16 of them, in a 33-page ruling that was very thorough and very, very clear that those arguments did not have merit, and they rejected all of those arguments. Subsequent to that ruling, the 5 petitioners have filed an appeal with the Court of Appeals. They submitted their written briefs on January 27th. We will have until February 16th to file our response, and then we should have an opinion, a ruling from the court by the end of May. I am confident that the Court of Appeals will uphold the LUBA decision. When they do that, the petitioners have the right to petition the state Supreme Court to hear the case, and it will be up to the Supreme Court whether or not they choose to hear it. So that is the current litigation going on right now. There are also 2 placeholder suits that have already been filed. Both Aurora and Wilsonville have filed in Marion County and Clackamas County, challenging our adherence to a different set of rules called the Administrative Procedures Act. Those are our current active cases. They are asking to stay those until after the Court of Appeals decision is determined. We are going to attempt to get the Clackamas County case dismissed for lack of jurisdiction, and then let the Marion County case move forward. I believe that even in circuit court under Administrative Procedures Act, I believe that we complied and that the board complied with state requirement. I believe these suits do not have merit. However, having said that, I want to share with you the cost of defending against these actions, and that we are not able to recover legal fees. This is just a cost that we have to absorb. So far on the Aurora Luba case, the legal fees just for Luba are $167,000. That does not include the Court of Appeals case that it just starting now, and it does not include circuit court case. That's just the Luba challenge at $167,000. In July of 2019, anticipating that this was going to happen, our agency entered into a pilot program with Department of Justice for a flat rate billing, meaning that they would only charge us based on the average of what we had in the previous biennium. We would be capped. Had we not done so, we would be facing that $167,000 just for the Luba case. As it was, since we were capped, we are paying $52,000 a year in legal fees for last year and for this year. The Department of Justice is discontinuing this program. It was a pilot program for small agencies only. I believe, I speculate that they are discontinuing it in part because of us. They are an agency that also has to recover their costs through passing on to their to the agencies that use their services. We are required to use DOJ for legal services, and so last year for fiscal 2020, they had to eat $177,000 of cost associated with Department of Aviation. This year, if the costs for the first 6 months also hold true for the second 6 months, they're going to have to eat $88,000 of these fees. The significance of sharing this with you is that this agreement ends in June. After that, we are paying actual cost, not an average or a flat rate cost. So the circuit court cases will likely not be heard until we're in our next budget in July or next summer or fall. So we will be paying the full cost of those. If it goes to Supreme Court, we will be paying for full cost. The Court of Appeals case that we're under right now is likely the majority of that cost is going to be in this next 6 months. So we will be still capped at that $52,000. Again, had we not done so, just the Aluba challenge would have been $167,000. So, and as you know, this agency is under significant financial stress right now because of the loss of revenues associated with the aviation fuel tax. And moving forward in the next biennium, we don't see a recovery. We see some recovery, but not to the point where we have not budgeted for this type of a legal challenge. And there is no relief for us. So whoever chooses to file challenges against us, we have no choice but to defend and to incur the cost of defense. So, legal counsel's advice to me is to try to avoid litigation. That's not possible in Aurora's case. everything we do associated with Aurora is challenged. So, so we will have the cost, what we've already incurred for LUBA, Court of Appeals case that we hope to have wrapped up in the next 6 months, 2 circuit court cases that we do not know at this point when they're going to be heard. One of them we'll try to dismiss. Hopefully we'll be able to, but we don't know what those costs are going to be. So on top of that, for us to move forward, I really want to move forward with this runway extension at Aurora. To do that, we have to do an environmental assessment, then we have to do land acquisition, then design, and then construction. Before we can do the environmental assessment, the FAA wants certain things.
Betty,
Yes,
this is Matt. If I can just jump in here.
go ahead, Matt.
Just to remind you and the board that the purpose of this executive session is to discuss the ongoing litigation. And if we get too much beyond ongoing litigation, we do run the risk of this executive session being able to be opened up. So I just want to reiterate that.
Okay,
And
okay, thank you.
encourage everyone to focus on the litigation issues.
Okay, thank you, Matt, for reminding me.
And I apologize that my camera's not on, but everything freezes as soon as I turn my camera on. So if it's off, I can at least hear everybody.
Okay, so I haven't broken any rules yet so far. Everything I've discussed so far is appropriate for exec.
I think we're good so far.
Okay, so to summarize, we would have spent 167,000 if we had not had this agreement. We've got 3 more court cases in front of us that we're going to have to pay for. We're not in a financial position to be able to continue to absorb these costs, and there is no other funding source for us right now. There is more I would like to discuss with you, but I will tell you, Matt, I can talk to him about the public records requests. Can I talk about that? Stacy, Matt? Can I talk about that?
Yes, yeah,
I can?
yes, we can
Well-
talk about that because well,
Yes, I can.
Yeah, Matt, can I jump in? I
please, Stacy.
disagree because that's not only, so the risk of all of this is that if somebody eventually wants to get a hold of all the minutes and the records that were discussed in this meeting, if it's a long shot, but if they were able to ask for all of that, have a court review it, there'd be a determination that we went outside the subject of the litigation. So since I keep hammering on the public records request, because I'm really concerned that they're actually part and parcel of all of the litigation and just an attempt to subvert discovery, then let's just go for it. I think that we can couch it as litigation.
Okay, so I can talk about the public records. Can I talk about anything else? Can I talk about the things that we are considering, the federal influences that are attempting to persuade the agency? Can I discuss that in here or not?
I'm worried about legislation and things like that.
I'm not going to talk about legislation. I'm not going to talk about that piece of legislation.
Let's try and stick to the litigation. So legislation
And federal influence?
I don't know.
No.
But let's,
Ladies, may I say?
I think it's better to just stay.
Okay,
Let's do this. Betty, give me a call afterwards. I understand it costs a lot of money. There's pros and cons, but the financials do not belong here. What we need to hear about as a board is the current legal status of where we stand, upcoming cases, and what our legal opinions are from our 2 new attorneys. So as such, because this is an executive session here to hear legal stuff, how about we let the attorneys tell us legal stuff? So if I could
Stacy,
get an update on cases and expectations of cases.
Sure, Maker and Stacy Postgate for everybody. Thanks for letting me come in today. I think I'm just doing a starring role while the land use stuff is going on. And then you will be in Matt Shoup's great hands.
Okay.
So there are two things going on. There's the appeal to the Court of Appeals of the Luba decision, which Betty just walked everybody through. When you appeal a Luba decision to the Court of Appeals, fortunately, there is a much shorter timeline. Those cases are run faster than any other type of case that goes to the Court of Appeals. So that's why we can expect hopefully a decision by the end of May. It could be till the end of July. I'm sorry, not end of July, but end of June. It's just we have other considerations, for example, COVID. So hopefully we'll have something before then. At the same time, the placeholder suits that Betty was referring to, I think there's actually 4 of them, but I think there's one but they're both in Clackamas and in Marion County. So what's going on with those circuit court cases is those were all filed by the petitioners in the land use case because there was a concern that Luba didn't have jurisdiction to make the decisions that they were asking for. And so we agree with that. That was our argument. The problem is when you are a state agency and you issue a final order in writing of any kind, there has to be a way to petition for review of that order. So if it's not in Luba, it would be in front of those circuit courts. It shouldn't be in front of Clackamas. They don't have venue, they shouldn't have jurisdiction, but the court can then review those arguments. What Nicole DeFever, she's your trial attorney, is going to do is rely very heavily on the arguments that Lucinda already made in front of the Court of Appeals and the arguments that Jonah, you have lots of attorneys right now, that Jonah, your appellate attorney, is going to make to the Court of Appeals. And I believe that Nicole's intent is also to do what's called a motion for summary judgment. All of those circuit court cases are what's called stayed right now, meaning there's no action on them. And they were waiting for the outcome of this Luba decision. As soon as the Luba decision came down, it's the chamber, and I can't remember all the association, Wendy Kellington's clients, they immediately moved to ask the circuit court cases, we want to get these cases going forward now, even though there's a Court of Appeals process going on. So where we are in the circuit court process-wise is we're waiting to see what the circuit courts decide, whether or not they're going to continue to stay the matter or not. I believe we've also filed something. I'm sorry, I'm not exact because there's, quite frankly, there are a ton of motions going on between record changes and motions to intervene and motions to stay. So that's where we are with the circuit court. So it is entirely possible, and I think we'll know in a couple of weeks, whether those circuit court cases are going to go forward or not. And so when that happens, I can come back and give you more of an update, or maybe Nicole DeFever will, because she can tell you what's going on in those. So most of what Betty was describing to you that was in the Luba decision, that's pretty much in front of the Court of Appeals too. I have other concerns because I also represent ODOT, and there's a whole issue with state agency coordination and how that works when you're constructing within a city or county. So one big thing that you should know is that, and the nice thing about having DOJ for you is that we're not just arguing to make sure that these rules work for you, but we also have to make sure that the other agencies that use them a lot, that the way that they've been using them is confirmed within the rules. So I think that's more of a status. I can talk to you more about the substance of what's being argued in both cases, but I'm not sure if you want to go into it in that detail.
I would like to hear at some point, because what we're going to have to do is come to a determination of whether we think we are strong enough in our procedure to press forward, or whether we think that, oh, you know, maybe we should redo some stuff. I mean, that's the essence of the question. For that, I really need for you and Matt, you're going to have to really get us into some details to let us feel, you know, our probabilities of winning one way or the other, if that makes sense. Our comfort level on being on solid ground.
So I agree with Betty, and I think that our case is very strong in the Court of Appeals for jurisdiction. I really do. And I think that I've been going back and forth through all of these arguments, and I feel like you should win on all counts with all the circuit courts, but I'm not a judge. The one thing I do want to say, because I'm not sure you have ever been involved in this type of this land use war. And it's just, this unfortunately is the way that happens. So you have, one thing to keep in mind is even if you follow your own processes to the T, there is still a potential for challenge because someone gets to make that challenge.
Yep.
And on top of that, not only do you have to do your own land use decisions, but you're going to have to go to Marion County and apply to them for certain land use decisions, which creates another opportunity for appeal. So I say this to kind of manage expectations. Doing a major plan like this, any type of plan, whether it's a transportation plan, an airport plan, whatever type of plan, if there's a bunch of petitioners out there that don't like it, they're going to be able to find an attorney to make your life difficult.
Yep. And that's,
So my advice would be, it's my advice, which I have been trying to give to agencies over the years, is just do your business in the way that you would ordinarily do it. And don't necessarily let the litigation stop you in the way that you think is the best way to do your job and what needs to be done.
and appreciate that. And I think we all understand that in today's, it's their right to fight their side. And it's our job to make sure that we're strong in following procedure, and we do it as our legislator has spelled out to do it, including with the FAA guidance. I see no other way than just to move forward and understanding that it's in today's legal world. If we ever want to do anything at any airport of any size, it's just what has got to have happen. If at this point we determine that funding runs our decisions here, then that's not a legal challenge. That's a funding decision that we need to have in open discussion. So legally wise, I am comfortable where we are, but I would like to open it up to the other board members to see if they have questions concerning our legal concerns, not our budget concerns.
So I guess if I can start, I have a question related to the public comments that were made early in our procedures, as Stacy just mentioned. Do we need to change any procedures that we have internally?
You're cutting out, John.
You're cutting
No,
it
I'm
off.
sorry. Okay,
John,
sorry.
you can't hear
So
you. Better.
I'll get a little closer. So in the early conversations of the public comment period of the meeting we just had, there was comments about changing our procedures and our internal procedures as far as meeting with them. The mayor of Wilsonville spoke, for example. And I guess, Stacy, are you saying that our procedures are just in place that we already have? We don't need to change them, that we're following what the procedures are in place, or do we need to change our procedures?
So unfortunately, I didn't hear the comments, so I'm not sure what they were.
So basically what they talked about, they want the intergovernmental case, which, John, according to land use, we are within we're in Marion County, correct? So Marion County, that's where taxpayer dollars pay. They are the ruling body for development in their county. Land use states that Clackamas County has no right in this. What the mayor wants is Clackamas County to have a right in that. As such, what they want is against current land use specifications.
All right. Thank you for that clarification.
Yeah, so what you've been hearing, and it's a very good argument by Wilsonville, is they say that we're not following Oregon land use. And they're not following that they say that we did not do the master planning process correctly. They're staying away from saying that they disagree with development at the airport. They say that we did not do procedure correctly. So far, everything has upheld that we've done procedure correctly.
Yes.
Now, if the legislation passes, that current piece of legislation that says that forces us and changes the land use law, then we'll comply with that new land use law. But until then, we're complying with the land use law.
Okay, that's why I just wanted to make sure, based on what I was hearing from Stacy. Thank you.
Yeah, and Chair Maker, so that's actually a question that is going to come up in the Court of Appeals, because that has to do, to some extent, not to some extent at all, it's your state agency coordination rule that requires you only to have to work with affected parties. And so affected parties is not only Marion County, because they're the ones that govern the land use and zoning where the airport is, but there's also a definition of people who are directly, or persons or entities that are directly impacted by the plan. So that's what they're going to try and slide under. But what I'm hoping comes out in the Court of Appeals are two things. One, I think, and I'm sorry, I haven't researched this thoroughly, so I need to make sure that you as a board, I think, get deference in how you interpret that rule. And so if you as a board decided that Wilsonville is not an affected party, then you should get deference. If something happens at the Court of Appeals to change that, and this is where Matt is going to come in, this is your rule. You can try and amend the rule. You do have to get LCDC to not acknowledge but support it because the way that rule is, but there are fixes to it. So no, I wouldn't change anything right now in the way that you're doing it. I would assume that everything you did was just fine. And that's the arguments that we're making to all of the courts. And Lou, I agree.
Yeah. Now, Tony, and back us up on making sure that, you know, the public, the committee meetings with the public during the master plan process meets that approval process that we have for that's laid on top of the state. I would just make sure that we're legal in that, and those two mesh. Because to me, that's how we reach out to affected parties, is with those public meetings during the master planning process.
And this is Matt, and I agree
Right.
completely
And
with
it drives me
what
nuts that they can even challenge that.
Go ahead, Matt.
said, Chair. I would just add, I would just add that as long as that we need to want to follow your rules very closely and very tightly, and not stray beyond them, because we've seen that people are going to contest that if we do.
Copy that. Now, within this, at our board meetings, when we have discussions on Aurora, we had talked about always having legal counsel present. Betty, we're going to follow that, correct?
Yes.
Okay. And so overall, what I hear is we're fine today. We want to stay within the legal land use policies, and the master planning process is spelled out by the FAA, and the strategic coordination process as spelled out by the state of Oregon. Right now, I'm hearing that we're good on both fronts. If we are not good on both fronts, this is where I really need the legal team to come tap on our shoulders before we go get on our horses and charge forward and spend a whole bunch of money and find out that, you know, we're all naked on top of that horse. That's what I need from the legal team.
So Chair Maker, all we can speak to right now is what happened with the master plan and that process. But if you engage in a new one, then definitely Matt, and with help from me, can assist you in making sure that you comply with that public participation process.
But say that again.
So, and I may be misunderstanding your question, but as to the master plan back in 2011, I think that your process for adopting that it was sound,
yes.
At least legally sound. And I can't necessarily speak to any other processes that you've been engaging in because I'm so new to this agency, and so is Matt. So I'm not really sure what other planning that you've been engaged in up to date.
Is our process. We follow the master planning process, and that's the only process we follow.
That's the only one. Okay. So if you do decide to go forward and amend the master plan, or excuse me, update the master plan, then we can work with you to make sure that you satisfy not only the public participation requirements, the processes you're talking about, but making sure there are findings and all of the legal stuff that makes this a sound decision to defend, ultimately in lieu of or whatever court.
Fantastic.
And that process will be similar to what we've done for all the other master plans that this board has adopted over the past year, the plan that you will be adopting at the April meeting. If I'm not allowed to discuss future plans for the Aurora Airport and the master plan in executive session, then I'm going to put it on the agenda for the next meeting.
Okay.
We need to discuss that.
All right.
I did not want to do that in a public forum because every single word that I say seems to be litigated or public records, or they misinterpret. Stacey,
will.
I can talk about that. I can talk about that. Can I?
Everything you say, you can expect for them to try to attack you. That's
just standard the course. Yeah.
Why would,
I'm sorry.
Why would they not do that? They have nothing to lose.
Okay.
So just understand they're going to do it.
Yeah. And they often misinterpret my positions or what the FAA has done. They absolutely do not understand when they ask for records. We give them the records, and they completely misunderstand and throw a little tantrum about saying the FAA rescinded, disapproved, or canceled your master plan. absolutely did not ever occur.
Okay, that's not part of this executive session.
Stacy?
I understand your frustration. We'll talk about it.
Okay.
But for right now, does anybody have any other discussions on the legal matters put before us concerning Aurora?
Okay, I just want to add one thing, and it does kind of tie in what Betty was just talking about and about the plan. One thing that you can always consider is settling all of this, but that would require you to have to comply with what it is that Wilsonville and Aurora and friends are asking you to do, and that is probably impossible, if not just difficult. So, or the other way around.
I think we all understand what happens if we, there's 3 parties that will never agree. So. Yeah,
But just so you know, it is on the table. It's always on the table as a possibility.
like that.
My questions are just around the financials, not on the legal stuff. Legal seems really solid to me. I just have more financial questions about it.
And Vince, at some point, you are a master, being there at Portland International Airport. You have a master's doctorate and beyond in how to make projects go forward in the face of public, maybe not wanting it to happen. So, on this, I would hope that, you can maybe chime in with me and Betty, maybe put our heads together, because you've got some experience in this that we just don't have. And if your guidance would be greatly appreciated in what your thoughts.
Okay.
I'd be happy to do that, but let's not, everybody's got something to say about that. So, but yeah, I'm happy just to share a little bit about some of the things that we've done.
Stacy, I could meet with 2 of them and it's not a quorum and it's not breaking any rules.
No, it's fine if it's not a quorum.
Okay.
So,
And Vince, if what you're worried about, sorry, if what you're worried about is using your personal experience to assist the board, that's not a problem. That's not an ethical violation. There's nothing wrong with that. You're all, I don't know if you're volunteer or not, but you're all expected to walk into this position with experience and to draw
No,
from.
I'm not worried about that at all.
Good.
So Betty, if you could just maybe over the next week, set up a telephone call or Zoom or whatever other meeting site exists out in the internet, and just get us 3 on board.
Sure. Happy to do that. Okay,
Fantastic.
so that was it for me. Any other questions from board members? And it's 2:10, and I appreciate you taking the time to talk to me this afternoon. I just wanted to give you an update on where we're at.
Right?
Hey, nice to meet our legal folks. It's great to have you. You guys do fantastic work.
Love to have the lawyers.
Nice to meet you.
Thank you. Nice to meet you all. Look forward to working with the board.
All right. Okay, guys, I'm off then. And this week, first of all, I got to do the little, we're now adjourned and then get us, come back into public session. Is that right, Kathy?
No, ma'am, the public session has been adjourned. This was a separate meeting of an executive session. So, and it was noticed, so
Okay.
we can now adjourn.
All right, well, I think we are adjourned then. Thanks all for coming. And once again, super staff work for this meeting, by the way. Just kudos to everybody around. Tell Jim and I, he's God sent.
Thank you. Okay, bye-bye.
Ciao, everyone.
Bye.